So I think we'll go ahead and get started today. Good afternoon and welcome to the ABA discussion room on immigration court issues. I'm Christy Gaines. I'm a senior legislative counsel in the ABA's Governmental Affairs Office, and I'm really pleased to be joined this afternoon by our expert speakers. Carla McAnders, who's a clinical professor of law at Vanderbilt University Law School, is also the current chair of the ABA Commission on Immigration, and Karen Grisey, who's pro bono counsel in the Washington, D.C. office of Fried, Frank, Harris, Shriver, and Jacobson. Karen is a former chair of the ABA Commission on Immigration. And we'll each be providing some information on the topic at hand, but hope that any of those attending who have questions don't hesitate to ask those. We'll get to as many as we can, and if we're not able to answer them here, we'll be happy to follow up with you afterward. Carla, I think since some participants may not actually be familiar with the ABA's work in the immigration area, maybe you could start with a brief overview of the Commission's work and the genesis of the policy that was developed to support an independent court.
Thank you, Christy. So since 1983, the American Bar Association has prioritized immigration law and policy as one of its core public service and advocacy efforts. The ABA Commission on Immigration directs the association's efforts to ensure fair treatment and full due process rights for immigrants and asylum seekers in the United States. So the Commission provides continuing legal education, recruits and trains pro bono lawyers, and operates 2 direct representation projects on the southern border, as well as a legal resource center serving children's immigrant legal services programs in Texas. We also develop a broad range of policy recommendations for consideration by the American Bar Association and advocates for improvement to immigration law and policy. The Commission's most significant policy and advocacy area is the erosion of due process safeguards and the lack of access to counsel and legal information for individuals in immigration proceedings. This led the ABA in 2006 to first adopt a position supporting the neutrality and independence of immigration judges, both at the trial and appellate levels, and of the federal agency by which they're employed, so that judges and agencies are not subject to the control of any executive branch officer. In 2010, after a multi-year study on the state of the immigration removal adjudication system, the ABA adopted a policy specifically recommending the creation of an independent Article I immigration court. That position was reiterated in a follow-up study in 2019. And we came to this conclusion because, as currently constituted, the immigration courts lack many of the basic structural and procedural safeguards that are necessary to ensure due process and fair and impartial adjudications. Thank you. Christy?
Karen, you were chair of the commission back in 2010 when the commission produced sort of the seminal court reform report that generated this policy recommendation that was adopted by the ABA. Can you maybe elaborate on some of the flaws of the current system that led for the recommendation for change?
Yes, thanks, Christy. I can talk a bit about some of the problems that we identified in 2010 in the first report, and then that between then and 2019 persuaded us that Article I was definitely the preferable option and the right way to go. First is the current structure of the immigration courts. Several different agencies play a role in immigration adjudications and in removal in particular, and the structure is a big part of the problem. Going back to the abolition of the former INS and the creation of Department of Homeland Security in 2003, we now have DHS controlling inspections, admissions, adjudication of benefits like green cards and naturalization, but also the initiation and prosecution of removal proceedings before the immigration courts. But the immigration courts themselves and the BIA are housed within the Department of Justice under the ultimate control of the Attorney General. So these 2 separate agencies have different leadership, different missions, sometimes different policies, and no real way to reconcile or reach common solutions in problematic cases. And the sort of final point is that DOJ, in cases in which an immigration matter goes into federal court, DOJ was not only the adjudicator below in the form of the immigration judge or the BIA, but becomes the prosecutor in federal court. So that's one problem. Also flowing out of the structure, the immigration judges are not true judges. They're attorney employees of DOJ without real decisional independence. They report to the attorney general. They can be reassigned, disciplined, or worse if they don't decide cases quickly enough, if they grant too many continuances to get a lawyer, if they write too many written decisions as opposed to oral decisions from the bench, and the like. Third has to do with the hiring process. The immigration judges are appointed by the attorney general through a system that lacks public input and transparency. Historically, it's also lacked diversity. And by that, I mean not only gender, racial, or ethnic diversity, but diversity in practice background, with most of the judges being former DHS prosecutors or other government lawyers or other agency judges. And that goes way back to under John Ashcroft, where it was well demonstrated that political affiliation for a time was the absolute litmus test for hiring as an immigration judge. So as you'll hear later on, that transparency in hiring is one of the topics that's addressed by the new bill. And I'll say the last two, IJs don't control their own dockets, and the case administration, the shuffling, the detailing, the prioritizing doesn't arise from the judges themselves, but from the management of EOIR and ultimately the Attorney General. So that has sent, for example, large numbers of judges detailed to the border with no work to do when they actually get there and find themselves stocking supplies on the shelves rather than hearing cases. And finally, the AG, Attorney General, has ultimate authority to decide cases through the self-certification process, which can be reversing a decision of the Board of Immigration Appeals through self-certification, but more recently, certifying a case to himself even before the BIA has had a chance to make a decision. So all of those issues are ones that we think would be improved by taking the immigration courts outside of the BIA and not leaving improvements, some of which we have seen under this administration, not leaving them to the whim of the Attorney General or the Director of EOIR, but enshrining them in our immigration law.
Thanks so much, Karen. So I will sort of segue from that to give a little bit of information on the legislation that we're supporting as a part of ABA Day this year. The legislation is H.R. 6577, the Real Courts Rule of Law Act. It was introduced on February 3rd by Representatives Zoe Lofgren, Gerald Nadler, and Hank Johnson, all of whom play key roles on the House Judiciary Committee. It now has 43 co-sponsors. And I definitely want to give a note of appreciation to Representative Lofgren, who has really been a champion on this issue and is working very hard to get this legislation through the House. It is actually, maybe as we speak, being marked up in the House Judiciary Committee today. The committee was still doing its work as I left to join this room. So we're hopeful that it's approved out of the committee and then it will come to the House floor soon for a vote. So this ABA Day timing is really perfect, and we hope all of you will join us in telling your members of Congress to support it. A little bit about the bill. It would establish an Article 1 independent court system. It would have an appellate division and a trial division. The appellate judges would be nominated by the president and subject to Senate confirmation. The trial judges would actually be appointed by the appellate body through a merit selection process. That would include stakeholder engagement, which was an important issue for the ABA and many other groups. It will help to improve transparency in proceedings by providing for the publication of court rules and precedent decisions. It will also help to improve some efficiencies in the system by enabling judges to manage their own dockets and courtrooms, and by modernizing some court operations, like the long-awaited electronic filing system that still isn't in place nationwide. So those are some things that I think we think it's important to highlight, because it's not just about obviously a core issue is fairness in the system for people who are in it, and fair and impartial adjudications, which are important in every court. But this also, we believe, will improve the efficiency of the court system. One thing I would like to note is that this bill does not change substantive immigration law. It does not provide additional immigration relief. The law as it stands today, where people can apply for certain relief or benefits, will remain. The court structure will just be lifted out of DOJ, the enforcement agency, and made an independent entity. We understand immigration issues can be controversial, but we really see this as a courts bill, a good governance bill. It's about making sure that, I think both sides of the aisle can agree on the core principle that once a case reaches a courtroom, it should be heard by a fair and impartial judge and decided on the facts and the law, and that there should be no opportunities for political influence or policy, influence. We have a lot more information on the bill and the status of it on the website. So we have a section by section summary, an ABA one pager, and other resources that you can go to see. And obviously, we also have the opportunity for you to advocate, which you can find in the great Advocate Here button here on the Huvelo platform, but also through the ABA Day website online. Maybe since I see we do have a few minutes left. First, I'd like to ask Carla or Karen if they would like to add anything.
No, Christy, I had the question, which is I saw people were raising their hands, but I didn't know how to actually get at it or see the questions. So maybe you can help with that.
So let's see if I can get a question in here. And maybe one of our tech people can help, because I've accepted the raised hand, but I do not see the question coming up.
Should we mention the lounges then if we don't resolve it in time?
So for those of you who may have questions that we can't address here, we have on the event site something called Network Lounges, and there is a GAO lounge where government affairs staff and some of our speakers can be available to discuss issues afterward. And so don't hesitate to go there if we're not able to get to you. And I can see someone trying to get in here, but
she might have to click the join now.
Not sure how to get them in. And their question, unfortunately, is not showing up on the Q&A function.
I'm so sorry that I didn't think in advance to ask, how do you deal with that?
Yeah, I apologize. I thought the questions would just come in through the Q&A function on the room. So I'm going to note the name of the person who is trying to ask the question.
I saw there were two. One was Fabian, and then there was another one too.
Yes, please go ahead.
I think they can enter.
Look at the side of your screen. There are 3 lines that you should be able to click on, and you can see a live chat as well as a question button. Okay, here I do see one question that has come in, and I'm just going to accept it. So, so hopefully others can see. Okay, so with just a couple of minutes left, Max Trujillo is asking, the omnibus for FY22 increased funding for immigration-related agencies, but how does the new funding help in processing quicker the backlog of asylum seekers? So if either one of you would like to take a quick minute on that, please go ahead, or I can say something very general.
Well, I think in theory, it adds more immigration judges, which should help afford more resources for processing of all kinds of cases in immigration court, not strictly speaking for asylum seekers only. And I don't know, Christy, whether that addresses affirmative funding for affirmative asylum cases at before the asylum offices or not. Yeah,
from what I know, actually in addition to increases for the Department of Justice for immigration judges, the Department of Homeland Security also got some increased resources for asylum officers and other staff to address backlogs, which really are